Should you list a probate home before the court letters are issued? This is a question I get a lot, and the answer isn't always black and white. I've listed a probate home before the court issued the letters, and why would a family want to do that? Sometimes it's about preparation, not selling. The home may be vacant, utilities need to stay on, and someone needs to keep an eye on the property, and that family wants a professional oversight while the probate process is moving through the court. From the seller's perspective, listing early can mean the home is being monitored, potential issues are caught early, and the property is being prepared for sale. But there are real costs. The estate or the administrator is still paying out of pocket for the utilities, the maintenance, insurance, and the holding costs. These expenses may be reimbursed later, but not immediately. From the realtor's perspective, listing early also has consequences. The agent may be visiting the property regularly, communicating with the seller about maintenance issues, and protecting the condition of the home, all without the ability to accept an offer or close a sale. And that means no commission until the court paperwork is complete and the home is sold. So why would a seller choose to list early? It often depends on location. The seller is out of town. Having a realtor involved can provide peace of mind. This isn't a legal decision, it's a strategy. And it's a decision that needs to be made carefully by both the seller and the realtor.